In this session, we are going to cover intent as it's used in criminal law. When learning about criminal law, there are 4 building blocks required of most crimes. The main 2 components we will discuss are the actus reus and the mens rea. The actus reus is the physical part of the crime and the mens rea is the guilty mind. Usually, it will be easy to spot the actus reus since that will draw the attention of the authorities. The act will be a stabbing, a shooting, a larceny or a physical act that is potentially criminal. However, just because an act was committed, there can be no guilty verdict unless there is an accompanying guilty mind happening at the exact same time. The simultaneous happening is referred to as concurrence. Physical acts, even ones that result in death, may result in no criminal liability unless they are accompanied by the requisite mens rea. In a few instances, there are certain crimes that require no intent at all and just doing the voluntary act is sufficient for guilt. These are called strict liability crimes. They are usually found in the areas of public health or safety. Examples are speed limits, statutory rape or bigamy. Strict liability crimes are the result of statutes or regulations. Please note, the 4th requirement for a crime is that the act was the actual and proximate cause of the harm, however causation will be covered separately. So a quick review will show that a crime requires a voluntary act, or an omission to act, a guilty mind, the requisite intent, concurrence and causation. But let's get back to the physical act. In order for the act to be considered to be criminal, it must be voluntary or volitional. This means that the act cannot be accidental or uncontrollable, such as when someone is having a seizure or sleepwalking. Now, in some instances, the lack of acting can also lead to a criminal charge. When there is a legal duty to act and the defendant knew and was capable of performing the act, but does not, a person can be held liable. The legal duty to act has many parts to it and can be remembered by the memory device, SCRAP. S stands for statute. There was a statute that required the defendant to act. C is for contract. The defendant was contractually obligated to act, such as in a babysitter or a nurse. R is for relationship. The defendant had a relationship with the victim that required them to act, such as a parent-child relationship. The A is for an assumption of care. This is a situation where a person begins to render care but then fails to continue the duty that was assumed. Finally, P is for peril. If the defendant was the one who put the victim in peril, they have a legal duty to render aid. Under the category of mens rea, there are 5 items of intent that we cover: general intent, specific intent, malice, transferred intent and strict liability. We have already covered strict liability, so we will cover the remaining 4 next. Let's start with general intent. This kind of intent is the basic form that exists with most crimes. It means that the defendant knew that the result would occur, given his actions. An example would be a battery. By volitionally hitting someone, the defendant knew that a harmful or offensive contact would result. In this scenario, there are no other goals present than to harm the victim, therefore this is a general intent crime. Other types of general intent crimes are rape and false imprisonment. The next kind of intent is called specific intent. This means that the defendant does the voluntary act but has an additional goal that is desired beyond just completing the act. An example of this is a burglary. A burglary is the breaking and entering into the dwelling of another with a specific intent to commit a felony inside. The physical part of the crime is the breaking and entry of the dwelling of another. The intent, however, is the intent to commit another crime once inside. In this sense, there are 2 crimes but they are joined together. If there was no intent to commit another crime once inside, then you would have something like a criminal trespass. Specific intent crimes are more common and lead to a wider range of defenses. Next we have malice. Malice can be used in 2 ways. One way is with arson. In this form, it is also referred to as recklessness. The second way malice is used is with a homicide. When used in this way, it comes in 4 different variations. They are: 1. The intent to cause great bodily harm. 2. The intent to commit a felony, which triggers the felony murder rule. 3. The intent to kill, or 4. The one in willful disregard for human life, also known as depraved heart. Our last intent is transferred intent. This isn't an intent like the previous intents that are a direct part of a guilty mind, but instead it allows the guilty mind of an attempted crime to be transferred to the physical act. For example, if a defendant shoots one person with the intent to batter but instead they miss and the bullet strikes someone else, the intent will transfer to the new victim. This will keep the defendant from using a claim of an accident or any of the defenses that another intent may offer. Under the Model Penal Code, or the MPC, they have taken the common law labels of intent and combined them under 4 new labels. These are all created by statute and are subjective tests except for negligently, which is objective. They are purposeful, knowledge, recklessly and negligently. Purposely is done with an objective or certainty that the desired result will occur. Knowledge is a form of intentionally. Someone that does something that has a mens rea of knowingly, such as receiving stolen goods, is deemed to have done it intentionally since they knew about it. Reckless is a conscious disregard of a substantial and unjustifiable risk. Negligently is the failure to be aware of a substantial risk. So there you have it. A quick review of intent for criminal law. We hope that this helps you in your studying.